I open the work session on the Special Committee on the Family Division of the Circuit Court. And as you know, and for the record, we had presumably finished our work last couple of 3 months ago. We looked at 4 different items and came to some good conclusions. We enjoyed buy-in from the judiciary, in part because they helped us along the way, or we helped them. And the speaker wondered if we were done, would we submit our final report? And I suggested to the speaker that it be the interim report and that we stay open as a special committee until the end of this legislative term, or at least October 31st. And the reason for that is I assume there might just be some items that we hadn't thought of, that somebody else would think of down the road that might be appropriate for us to look at. And in the event, 4 things emerged. 2 things had been assigned to the special committee on the DCYF that the Speaker's office, and I think rightly so, decided were better placed with us. Second, the third item is, I don't know how it came to us, but the third item is on the agenda here. And the fourth one was submitted by Representative Gregg. So what I plan on doing, and you've all been sent emails and you all have hard copy in front of you, is to go through each one of these items and see if there is sufficient interest to form a subcommittee. We do not have all of our members here, but if we as the group of people who are present think there's merit, I will communicate then with those who are not here and see if they are interested. And if there is sufficient interest, we will make this a subcommittee. I will appoint a chair to that subcommittee. And of course, 91A rules apply. You may not have a meeting of a majority of the members of the subcommittee unless it is advertised in the calendar, held in a public place, which rules out this building for July and August. Also, you cannot have a private meeting with more than a majority of people to discuss it anywhere else. You can, however, have a one-on-one discussion with another member of the subcommittee. If it is a large subcommittee, perhaps it could even be 3 people discuss, but it has to be more than 50%. You can have a conversation, any of the members of the subcommittee, with people in agencies, special interest groups, people you know who care about this. Our committee researcher, once we know what subcommittees will be constituted, will start the process of doing the research that's needed to see what other states do on this, what current law might say to inform us. Any questions on the process? I jumped the gun on an opening remark. Representative Joe Alexander, Republican from the Judiciary Committee, is no longer a member of this and has been replaced by a Republican from the Judiciary Committee, Bob Lynn. The first possibility is to research Title IV of the Social Security Act. This is all on your handouts here. Specific to the state of New Hampshire. How much is collected? How? Why? Where does it go? Representative Jess Edwards, formerly of Health, Human Services and Elderly Affairs Committee, presently chairman of Division 3 of Finance, wants to be on board as a consultant in this. This is an important thing to him. Research Title IV of the Social Security Act specific to the state of New Hampshire. How much is collected? How, why, where does it go, and so on. Any thoughts on item 1? Vice Chair.
Thank you very much, Mr. Chairman. I need help, and I'm turning to you for help. Can you help me understand what the relationship is between Title IV of the Social Security Act, specific to the state of New Hampshire, and the Family Division of the Circuit Court?
I yield to anybody who knows anything about this. Yes, yeah, sorry for the insult. Attorney Cregan.
Good morning, Erin Cregan, General Counsel for the Judicial Branch. Title IV includes a number of subtitles. Typically, we think of A through E, and they include things like temporary assistance to needy families and foster care grants. The one that involves the court system the most is subsection D.
C is in Charlie.
D as in Delta,
Okay, thank you.
which involves child support payments. Under Title 4D, states are eligible to receive reimbursement for up to 66% of the time that's spent on child support obligations, typically connected to the TANF and Medicare programs. And that's been implemented in New Hampshire since the 1980s. It's implemented in all 50 states, that there is a reimbursement for time the court spends on these, which every year it varies how much money is collected, but it's between 6 and 1 million.
Any further questions for Attorney Cregan? Yes.
Oh, no, I don't have another question for the representative from the court. I do have a question for you, and that is, again, I'm quite familiar with Title IV of the Social Security Act. I don't know why it would be this committee that would be charged with finding out how much is collected, and how and why and where does it go. We have the LBA, we have HHS. Why would it be this committee that would be the best place to look into? And we have, in terms of legislative committees, of course, we have finance. Why would it be this committee that we would go to?
Representative Lynn.
Yeah, my understanding, I may be completely wrong on this, but my understanding, and I believe it was from discussions with Representative Kuta, but I could be wrong, is that apparently there has been some claim that because of the federal funding that is provided to the Office of Child Support Enforcement in DCY, in the Department of Health and Human Services, that somehow causes that office to be more aggressive, I guess it would be the if I'm the right word, more aggressive than it should be in enforcing child support obligations. That as I understand it, that's the claim. It's been quite a while since I did child support enforcement stuff, but when I was doing it, it was the DCYF was getting, the Department of Health and Human Services was getting federal funding for that. I never had any sense that was causing DCYF to act in some way that it wouldn't have acted otherwise. But, maybe I'm wrong on that. But anyway, that's my understanding of the claim. I'm skeptical that there's anything to the claim, but that's what I understand the claim to be.
But Mr. Chair, if I could follow up on
Please.
that, even whether you're skeptical or not about the claim, I don't think we have to reach determination on that. I think that this is a matter that belongs elsewhere. It belongs in Health and Human Services. It belongs in the legislative budget analysis. It belongs in finance. I don't I don't see, and no one has yet said anything that would indicate why, how much money is collected and from whom and what belongs in the family court. And I won't belabor the issue. It might just be that I'm a slow learner, but and I wouldn't argue with that. But
Attorney
I just don't
Cregan?
see it belongs here.
Attorney Cregan, I think I heard you mention the word court.
Yes, sir. Insofar as Title IV deals with TANF and foster families, it is money that is going to DHHS. It is only child support funding that is collected and reimbursed to the court system. For those who work on those issues, we can get about $66 out of $100 for that time if we submit time logs to DHHS, who then submits them to the federal government. It's a not insignificant amount of money, but it's a small percentage of the overall running budget of the circuit court. And there is absolutely no impact on the judgment of child support referees or judges. That is both statutory and a requirement of due process.
So would it be your conclusion that there is some narrowly focused warrant for this committee to look at Title IV Sub D?
I don't want to weigh in on your debate, but 4D would be the only part in which the courts would have a role as opposed to DHHS.
Okay, so yes, Representative Ball.
Thank you, Chairman Pearson. I'm sorry to keep raising my hand. Just a clarification. I believe that when we were originally talking about this, the concern that was being brought forward to us was from people who came to testify that they were not aware that they did not have to participate in the program. And so they were participating in a program where they actually didn't need to. They could have just made payments on their own without going through the program. Or I could be mixing this up with something, but that's how I believe people who came to testify said that they weren't given the option not to participate and that they were not aware that they had that option.
I'm not certain what that individual person's circumstances are. I will say that if you are a TANF or Medicaid recipient, I think that in order to receive those benefits, you typically do have to go through this program. And that is the most frequent user of it, although there can be some others that decide to use the process because it can be more convenient for them.
But those would be off topic to us.
Those are programs that are administered by DHHS.
Thank you. Representative Long?
Thank you, Mr. Chairman. So without being involved in TANF, if my spouse and I agree not to go through this, is that not to go through the Division of Child Support? Is that historically with the courts okayed, or do they still have you go through the Child Support Division?
The Title 4D imposes certain obligations on the court system to, for example, block schedule all of the referrals through the Bureau of Child Support Services. But the laws in New Hampshire are not markedly different outside that administrative aspect of it. So I don't know that you would not be necessarily in that block scheduling where you have multiple Bureau of Child Support claims being brought one after the other, but it might not make a big difference to the underlying case. Although I think if your non-cohabitating parent is a TANF recipient, then they have to show that they've done their due diligence to assign that claim over. So if you're not participants in those programs, the legal standards on child support may still apply, but you're probably not going to be block scheduled with one of these cases, which is multiple Bureau of Child Support Services claims, one after the other.
Okay, very good. Thank you.
Based on what we've heard, if there's no further questions about whether a very narrow subset of this is an appropriate subject for this, who present would like to serve on such a subcommittee? Representative Katab has already indicated to me she would like to. Is there anyone else? Representative Ball? What else? This could gain you some votes, you know. Okay, there's three, and I will put this question to the members who are not present to see if there's anyone else, and based on that, we may or may not constitute this as a subcommittee. Stay tuned. Item 2, also passed on to us from the Speaker's office. Originally, this had gone on to the Special Committee on DCUIF, but it was deemed more appropriate to come to us. And this is to address potential ways to address perjury. You may remember, both in, some of you, in Children and Family Law and all of us in this committee, except for Representative Lynn, we had numbers of people who alleged opponents in various trials were committing perjury, and therefore the judge was remiss in not knowing that and dealing with it accordingly. This question did come up a lot. Allegations we heard from numbers of people where that person was lying and I can prove it. Well, okay, what should happen next? If somebody makes that allegation, to what degree should family court be required or strongly suggested to go to the next step? You believe there is perjury. We certainly want the whole truth, nothing but. So what do we do? Again, Attorney Cregan, anything from judiciary that you might like to say? I know you're going to do a wonderful job with whatever we come up with, but anything from your end?
My pleasure to be helpful to you if I am. I hope that I am. I can say for perjury, it's of course a criminal offense. It has to be investigated and prosecuted by the executive branch. I have had
By the which branch?
the executive branch, that unimportant branch that isn't here right now, isn't represented
Yeah,
here
but
right
they're
now.
watching.
Oh, I'm sorry. I think they certainly are watching. Well, I'll apologize later.
Strike that from the record. Okay, go ahead.
Thank you. So there's not a major role for the court system, of course, unless they hear the perjury case later when it's brought for a criminal trial, which would be in Superior Court. It's a Class B felony. I do certainly, and I'm sure you do the same when you talk with constituents, if they feel as though they have proofs that would meet the reasonable doubt standard or that it could be gathered to make sure that that's investigated. I think the tremendous difficulty that people have, and I understand why it is so stressful, is that they know what the person is saying is false. But it's difficult to have proof that a jury would find persuasive beyond a reasonable doubt, particularly if it is one person's word against another. That's a very difficult thing for 12 unanimous strangers to say who's telling the truth and who's not. The more you have in terms of contradictory statements, in terms of a person maybe admitting to you in text that they got you in court today, things of that kind, or things that the jury can look at and consider. I did try to talk to a couple prosecutors before coming because I knew this was a subject you'd be looking at, and they do take perjury cases from time to time, but I can tell you that the impression that I got, and it matches with my own experience when I used to charge material false statement cases as a federal prosecutor, juries have a high standard. They really don't want someone who's just mistaken, who's just misspoke. Typically, the best evidence that I had the most luck with as a prosecutor was a person admitting in writing or video that they had lied, and at some point having an understanding of why they had lied. So it is a challenge to meet that reasonable doubt standard with a jury, and I'm sure that's a factor in the cases that county attorneys investigate and prosecute.
To what degree does provable intentionality play in perjury?
So it does depend, but for perjury, it does have to be material. So it does have to have it potentially impacted the outcome of the proceeding. A statement that the person does not believe to be true or knew to be false would be
Intentionality.
required. So it is certainly not mistake, inadvertence, misremembering. It has to be some intentionality there, that the person wanted to mislead the fact finder.
A couple of people spoke to me privately and thought that if these individuals said that is a lie and I can prove it, it's like the proceedings must grind to a halt, and that issue must be addressed before it could continue. And then put alongside that, if the judge concludes, even if so, it does not materially affect the outcome, should the judge state that? Do the judges state that?
In general, the trial process is intended to create that opportunity to offer the relevant evidence. And so it might not be offered at that time with that witness. You might have a chance to offer that relevant evidence later in the trial. And it may not grind the proceedings to a halt. It may be that you get that evidence in at a later time. But I think it's often the case. These are very tough cases. These are the worst thing that happens to most people, is being divorced, not seeing their children as much as they were going to, not living in their family home anymore. That the thing that they are very invested in, and that they believe that maybe their former spouse, their co-parent of their child has lied about, is not something that would legally affect the outcome of the proceedings. And so if that's the case, the court may say that that's a collateral issue, essentially, that if someone has lied, it's still within your purview to bring it to the attention of law enforcement. It's still something that you can report, but it may not be something that would impact the particular legal question which is being adjudicated at that moment, depending on what that fact is.
Do you think that perhaps a greater statement of clarification could be made by the judge at such time, so the person claiming the other party was perjuring would understand how the process is working and not feel like the person's just being waved off?
I know that's something that judges take very seriously, especially when you're dealing with two self-represented litigants, is wanting to make sure that they understand the process as much as possible. And the exact way it presents in each case is a little different and a little individual each time. What it is that they want to discuss, what is being adjudicated at that moment, what evidence they want the court to consider. So I think that's something that judges take very seriously, is how in that individual moment you communicate with this self-represented person and help them to understand what's happening in that proceeding. But I'm not sure even those that do their best and try their hardest bat 1,000 and always get that through in the way that they hope to and want to. And I know it's something we're always working on, is better communication with self-represented litigants.
What I've tried to do throughout the process of this special court is address the excited testimony of numbers of people who feel there's something bad going on, to take what they're saying seriously, and if possible, give reasons why certain things are being done the way they are. I believe some people, when an explanation is made, will be, unhappy it went against them, but understand it. I also know some people will never do that no matter what you say, but I want to take those who are reasonable and with an explanation say, okay, I get it. So what my question is, can we do anything here to improve what is being alleged with the statement of perjury for those who could come to understand why?
And I guess so that I can kind of take that question back, is it that you're hearing from constituents that they're not understanding the role that an accusation of perjury plays in a family case? Because we are constantly training judges on what are the common issues, what are things that you can do to communicate better. We have an office that deals with community engagement, where we particularly look at issues with self-represented litigants and how we can handle them better. If there's a common problem, we definitely want to look into that, what we can be doing better, and training judges on it.
This could be one of the many subchapters of that wonderful book I know you guys are working on, that is given to anybody who comes in pro se, your day in court, with all of these questions that arise where there's wonderful explanations on them. Representative Ball.
Thank you, Chairman Pearson. If I recall correctly, and I could be wrong. The people from the public who came to testify before us, the concern they brought was specific to falsified police reports in which the person then acknowledged that they falsified a police report against the other spouse, but then no perjury charges were filed. And I believe we even asked someone from the court, and I can't recall who, or from one of the organizations, departments, how many perjury charges have come out of family court. And I believe the answer was 0 in the last 10 years. So I think what the public's concern is, if someone falsifies a police report, what is the penalty? Because according to law, it's supposed to be you get charged with perjury. But if that's not happening and we continue to have people falsifying police reports in order to put themselves in a better position in the family court, how do we stop that? We don't want to clog the courts up with a lot of perjury charges, but how do we get that recognized within the family court that it's unacceptable and that there has to be some accountability? Obviously, the children, you can't involve the children in the that can't affect the where the children are going to be located, but there still has to be something. How do we stop that? I think that's the question I would like to know.
That's a very good question. And one thing I will say is perjury is one of a few different charges in Chapter 641, and one of them is false report to law enforcement, which is a misdemeanor, so it doesn't go before a jury typically. I think it's an uncategorized misdemeanor, so I think it would go to district court. And one thing I would say is it should be reported. It should be reported to law enforcement if that has happened. It's difficult for the family court as an adjudicatory body to give the redress that people want. But if someone has falsified a police report, that is a crime. And that is something that the police have the power to investigate and the county attorneys have the power to charge. It's unfortunate to hear that doesn't happen, because it does seem as though you're hearing cases where that may have happened. And we do have a statute that looks to me like a perfectly serviceable criminal statute that covers that conduct. So I'm not sure where the breakdown is, but I would encourage litigants to make that report directly, because there is a criminal statute that covers that conduct.
Representative Gregg.
Thank you. I wasn't sure if you see my hand down here. I
I've
did.
learned to see hands at
Representative
the end of
Raymond.
this table.
I did want to her reaches. So I think it's also important for us to remember when we think about, is this something that's, something that we should take up? Even though we have people that say, well, this was falsified against me or whatever, that's always very, very relative. And truth can be relative, which I know people like it to be black or white, but what one person sees in an instant is going to be very different. I do know that there are many people that lack insight into their own behaviors, and so they might think that something has been falsified, but when you really dig into it, it did happen that way. So I'm not sure that this is something that we should really look into. We do know that there is something for false police reporting. We've passed, bills on, blatant, I guess, to make it more criminal if you have a case of abuse where you've determined abuse or whatever. But this is just one of those very relative things. And I sat on that special committee on DCYF too, and where we think, oh, well, if we make somebody take an oath, they're definitely going to tell the truth. Or if we tell people you have to tell the truth, that's not how that works. As a matter of fact, I think that the study of people will tell you that the more somebody says that they're telling the truth, it's usually the negative. So this is all very, very relative and not something I don't think that we can legislate over.
Our history here, as you know, is we haven't brought forth bills as a committee, but we have had dialogue and conversation, and I like how that's been working. Representative Lynn, my guess is that you know a little bit about this.
I probably do. And I think, I guess I have two comments. First, in family law cases, there are, again, my experience goes back a ways, but I did have a fair amount of experience, that there are it's not at all uncommon for one side or the other to be claiming that the other side is lying about something. Actually proving that that's the case is very difficult, which is why, there are very, very few cases that are actually referred to the executive branch for prosecution. And candidly, I suspect, I mean, you have to talk to somebody from the county attorney's office about this, but I suspect that even if cases are referred, most of the time, the county attorneys will regard this as something of relatively low priority in the overall scheme of things. The prosecutor is going to be told, okay, here's a case where there's an allegation by one party that another party has lied in some court proceeding. How important is this in the overall scheme of things? And I suspect that many prosecutors would say, it's not all that important, particularly if it's not, for lack of a better term, a sort of slam dunk. If you actually have a case where somebody has filed a police report and then has admitted that the police, that it was false, sure, that may make a prosecutor more inclined to want to move forward with it. My suspicion is that there are not all that many cases. So I think that I guess I don't think that this is unworthy of looking into, but in terms of, the prospect of having, coming up with a sort of better solution, I don't know. I think we would certainly have to have the prosecutorial authorities involved in this, and maybe getting them more attuned or more willing to prosecute those kinds of cases.
I want to be responsive to the people who have come to testify before us when we had open hearings, both here and in Children and Family Law, that we're taking the concerns seriously, which may mean we have a one-pager on describing what's next. If you believe that a perjury has been committed in your case, here's what you can do next. Here's the standard you need to come up to. Here's whom you call, but something so that the person believes he or she has been taken seriously. Even if after that it doesn't go anywhere, I want them to understand we are responsive. I mean, this is the worst time in your life, and we don't want to be insensitive. Now, it may come to nothing, but I could just, well, maybe not, but if I were in this case, I would want to have something in front of me that if I said, Your Honor, I think perjury's been committed, I would have something that tells me, here's what I do next. Here's what I need to have in my hand. Here's where I need to go. Here's what we're not going to do about it right here. If the judge says, even granted, it will not materially affect the outcome of this case, I need to have all that on one page. That would be a help, I think, to some who feel justice isn't being served. Representative Ball?
Thank you, Chairman Pearson. And I don't know if this is way off, Attorney Cregan, you can let me know, if this would be way off base, because we know that it would be very hard to prove that perjury or even giving a falsified police report, because when you write the police report, you may have believed that that's truly what happened. And after you think about it, it's like, well, maybe it didn't quite happen that way. I was emotional, whatever the situation. I don't know if it would be appropriate, and more than likely it wouldn't be, but is there a way of marking the file so that we don't go forward and the other person may say, well, you can't go forward with these claims, but somehow we could tag the file to say that there was an indiscretion on one part, just so that we're aware that and the court or the future judge is aware that something happened in the past, and we want to make sure that everyone is above board and not misrepresenting the truth in the future.
So I know what some judges do if they think it isn't uncommon, let's say, for example, for one parent to say, I took care of the child every time the child was sick. And the other parent says, I took care of the child at least half the times they were sick. And they both think something very close to that is the truth, and the truth is maybe a little bit in between. I don't think that would be something that a judge would stand out to a judge, because it's understandable why someone would misremember that a little bit. But there are certainly instances where someone says something in one hearing and then says something that is clearly different, not reconcilable in another. And I think some judges adopt the practice where they put that in an order, and they do have that kind of noted, particularly if they think any records may have been messed with. They note that, and sometimes they do, if they think there's pretty strong evidence that that happened, send it over to the county attorney's office. So they have the clerk CC county attorney. Some of those are compelling to the county attorney, sometimes they're not, but those are instances where they can then flag on the record. If you look at Exhibit 18, Exhibit 22, you're going to see something that might be of interest to you. So you do sometimes see judges do that, but it would not typically be for the case where one parent remembers a little differently how often they took care of a child who was sick, because that's human nature, really. That's probably not deception on the part of either person. A situation where records look like they might have been messed with, completely contradictory testimony comes in, I think you do see judges try to put that in orders and forward it over, so that if it's persuasive to a county attorney, they might do something with it. And I did talk to one county attorney from Stratford who told me he had charged those sometimes. He had been able to go back in the records and see that the person had entered two documents that contradicted each other, and that was a good enough case for him to charge.
Vice Chairman.
Thank you. I apologize for not having my notebook with me today. Can you refresh my memory as to roughly how many cases a year a family court judge sees? Ballpark.
You know, I was ready for a lot of questions. I can tell you that Title D, 4D came in 1975 and it was implemented in New Hampshire in 1985. But I have to tell you that every time I come, Rep. Bickford will turn to me and say, but what about the public quarantine laws? And I have not prepared for that specific question. And then I feel as though I've really let him down.
There would be no reason for you to have.
But it is voluminous, certainly.
Let me ask another one, and if it's the same answer, I completely understand. How many family court judges have what I, as a layperson, would call their own clerk to keep track of records and take care of all the work that in almost every court in the United States
The budget
clerk
writers
does?
listen carefully to the answer, please.
We have about 44 judges that hear family cases and 3 staff attorneys that cover any issues related to the entire circuit court.
Thank you. So that if I could then, even if the number of cases that a family court judge has is theoretically manageable, what is the likelihood that a family court judge working full-time on family court matters is going to know and have the time to record in an appropriately accurate way indications of the possibility, unproven, only alleged, that there might have been some inaccuracies?
I think that's a good question. What I used to say when I was a Fed, every time Congress asked for something to be recorded, I said every question is $40,000, because we have to hire someone to sift through all the records and look for this question to be answered. And if it's 5 questions, then we need $200,000 to kind of look through and answer every question, because I think sometimes there's a view that's very, very easy to have an extra box, but there's a certain amount of time over hundreds or even thousands of cases that's associated with that. And then it has to be audited to be sure it's correct. So it's not easy to consistently track things that there's not a business need to track. You, of course, track the location, you track the parties, but you may not track incidental features of the case. But I do think, and I think also it's very, very common for people to disagree about the facts. But it's not so common that there is good evidence evidence that's noticeable to a judge that they say this is something, this pleading and this other pleading don't match. And that's why in the relatively few cases where it happens, a judge will have the thought that I'll memorialize that in order. But to memorialize every instance in which a person accuses another person of lying and they may simply have different memories would be a very big lift.
Thank you very much. If I could just, without trying to take too much time, Mr. Chair, I would like to go back to the draft report that we have prepared so far and suggest to you that these problems and many others could be solved if, number one, we took the committee's suggestion of more detailed training and education for the judges. Number two, if we could find a way to make clear that the nominees for judges should be people who have had professional experience in the courts to which they're going to be assigned, and those and similar steps that we recommended would address this in a much more meaningful way than us trying to figure out he says, she says. And I'd just like to have us think about that a little.
Thank you, Madam Vice Chair. All right, let's come to a conclusion on number 2, potential ways to address perjury. Remember, we want to say to those who have come before us, we take your concerns seriously. We cannot revisit your trial. We are not an appellate court, but we can look at process and see if the process might be changed in any way. Even if it is to conclude we don't have any recommendations, at least we've looked at it. So I've asked Representative Lynn if he would be willing to chair this subcommittee if there are sufficient workers on it. Who here would be interested in working with Representative Lynn on this subcommittee? All right, Representative Gregg, Representative Ball, Representative McMahon. Okay, so I will constitute this as a subcommittee with Representative Lynn chairing it. We have Representative Gregg, Ball, and McMahon as members, and when I send out a follow-up on this meeting, there may be perhaps 1 or 2 more. And so we would be good to consider whom should we be speaking with, and what do other states do on this subject? Has this been looked at before? And is this a worthy subchapter in the book, Your Day in Court, that we're all writing? Thank you. Item number 3 on the list, that we might consider researching implications of implementing trial by jury in family court, which various people testifying have requested. I don't prejudice the outcome as to what this subcommittee would conclude, but it may be worth it since people have asked, why don't we have this? If we conclude why indeed, let's move towards this. Or we may conclude because almost nobody else does it because there's 15 reasons why we shouldn't. Whatever the outcome is, any discussion on this question number 3?
I do.
Yes, Representative Long.
Thank you, Mr. Chairman. So we're looking for a jury. The jury would be seated at every hearing. It could last for 2 years, 3 years, 4 years. How do we change the jury? I think there's a reason why they're not, there's not a jury because of that implementation.
Okay.
So
Anyone else? Want to weigh in? We can hear from the court.
I often say I most know what we do in New Hampshire and sometimes less what's done in other states. But I did study for this question, and I can tell you it is relatively rare. I think a minority of states have jury trial because of the traditional division between law and equity in the court system and what had a jury and what would go to a court of equity. Most states follow the tradition that it is not a jury trial, but there are exceptions. And I think the exceptions that you see are typically in single instance, highly fact-based determinations. So for example, some states have had jury determinations of paternity. That's less exciting now that we have DNA testing, but that used to be something where credibility and fact-finding was potentially a very important factor. For states that had fault divorce, where you were determining whether someone had committed adultery, something like that, there were credibility determinations and fact finding that a jury potentially was helpful with. Now that more states have moved away from fault divorce and now the paternity is relatively easily established through DNA, I think you see it's a little less common to have juries in a wide range of procedures because of the problem that families come to the courts repeatedly for modifications of certain types of orders. You would not be able to constitute that same jury. You would have to have a new jury each time. And even in states that do have jury trials for some issues, they do not use them for others. So for example, when you're looking at this issue, you may find that Texas is the absolute high watermark of number of questions in family law submitted to a jury, but there is still a very large number of questions that they do not want the jury weighing in on. I think division of property is one. I think only one state allows custody determinations to be made with jury input. So it is not extremely common. But there are a couple states that do it, a few states that do it, but they tend to focus on very factual one-time determinations.
Vice Chairman Smith.
Thank you. Am I completely naive?
I'm sure not. I can't even wait for the question to end.
Well,
Not in
actually,
evidence.
I wouldn't jump into it if I were you, because I could be completely naive about this. I don't play lawyer on TV, and I never have. But I was under the impression that juries determine facts and judges determine law. And I see that as an important difference. Is that old-fashioned?
No, ma'am. That is certainly correct that judges typically make legal determinations. Judges do also make factual determinations in a broad range of circumstances. In the American system, we don't have juries ever making determinations of law. And that's part of why even in the states that have adopted juries for family cases, they still bifurcate the questions of what the jury looks at and the determination of ultimate legal issues in a lot of cases. So even if you decided to, for example, start with one, you might still say, well, the jury will find who was telling the truth, but the court will make the property determination or the court will make the custody determination. And I think that's what you'd find that other states do as well. But that doesn't mean courts and judges can't find facts. The typical historical division of the right to jury trial has been where we had them in the courts of law at the time of the founding of the United States, which is criminal trials and certain types of civil trials, but not typically family cases, which is why so few states have that.
Do we wish to proceed in making a subcommittee? What's your thoughts? Simply, yes or no? No.
I would say no. Can I expand?
Can you abstain?
No, expand.
Expand.
Yes. I
We
just,
will impanel them as, yeah, go ahead.
to me, it seems that the jury would be more in a criminal court, and unless this was in a criminal situation, I don't see a jury in family court.
Okay. No? Okay. So we're not going to go forward with this. maybe some other group at some other time. Since we do have 4 proposals that we started with, and we have 9 members, it would not be bad to limit the number of projects, subcommittees, and so on. Number 4, Representative Gregg, would you make your presentation, please? This is 4 on the bottom of the handout.
Sure, I'd be happy to. And thank you, Mr. Chairman. And I've talked to Attorney Cregan about this particular case. So I had a constituent call that has had guardianship of her granddaughter for many years. And I suppose what they're supposed to do, according to the paper that I have, is have an email that's registered. And I did talk to Representative Macbeth yesterday at great length about the process of this, because she's familiar with these cases, that in particular in guardianship cases, they have gone to electronic and not paper. So that explained that a little bit further. But the guardian filed her paper in September and thought that she probably didn't have to do anything for another year. The mother, within 2 months later, filed to have the guardianship terminated. Had a hearing. The grandmother had not checked her email, so did not know any of this was happening, and found out that she had lost the case by virtue of her not protesting, by the police knocking on the door and saying they were taking the little girl immediately. Which is pretty extreme. So I guess what I'm interested in, and I want to make sure that I'm focusing on the right thing, I do see the personal responsibility element of knowing that we need to check email if you've been told that. And actually I have the motion to terminate guardianship that I've redacted with any pertinent things, but it does say on there that they had to, the email address that all interested parties are required to keep and monitor. But also what happened, what that does to that little girl when they just show up. If this has been a guardian that has been communicative, is all of a sudden not communicative. And then we're just going to take custody of a little girl who's been in there for, I think, over 7 years with her grandmother, and going to stay with her mother, who she's not seen now for most of the year. What does that process look like? And is there anything that we're kind of missing in there that we would, are the judges doing anything like, oh, we haven't heard from this person, do we give them a heads up? And maybe, I think that Attorney Cregan has looked into it, so maybe she's got some input.
Hello. Thank you for bringing that case to our attention. Because these are confidential cases, I'm just going to speak hypothetically. The constituent is totally free to discuss it with her representative, but I, as a court system person, have to be a little bit more careful. But we did do a review, and I think there is room for improvement here. I can say that very few circuit court case types have been transitioned over to electronic, and guardianship is one of those case types. And mostly people prefer to use their email rather than mail, but that's not without some unanticipated consequences. And there can certainly be a case where a person gets court email and for some reason it goes to their junk folder and they don't see it. There is a process generally in place for guardianship cases where if the email bounces back, a letter is sent. I think our view is that in light of learning this, we need to also send a mail letter when the email is not read, which we do have the ability to go in and check. But that would only respond to this one particular case, and I think we can make that change in our procedures, and we see that there's room to do this better. I also referred this question over to our Community Engagement and Access Committee because I think there's a broader question about expanding electronic case types in circuit court where people are very used to them being mail, and whether there are any unanticipated consequences. And I don't think this is one example of one consequence, but I think we want to look into whether there are potentially others, because attorneys, if an attorney is using their law firm email, they are checking that email always. They do not have messages from the court going to their spam folder, but that could happen with a private citizen. So I think there's learning as we expand in case types where most people are self-represented to email notification, and that's something we're reviewing. But I think this does show us that there was a procedure change that we needed to make, that if an email was not opened, we also needed to send a physical letter. But there may be others. And if you hear anything from your constituents, from anyone who's on YouTube, send a letter to the AOC. Our email is online, or send it to me, because we do want to know. we do want to fix procedures that are not working for people.
Would you find it helpful if a subcommittee were to meet with you and perhaps a few others from judiciary to examine this issue?
I defer to you, but I would encourage anyone, whether they're a member of this subcommittee or not, to reach out because we want to know when things are not working for the
Well,
people who use the courts.
that is the gracious way in which you have interacted with us thus far. I just want to check. Anyone? Representative Lynn?
So can I just raise a question? Am I correct in understanding that if someone is starting a lawsuit, in other words, the very first filing, that the notice of that to the defendant does not go through email. There would have to be serviced by the sheriff or whatever. Is that correct?
It depends on the case type, what types of services are accepted, but it can be mail service, it can be serviced by the sheriff. So it's particular.
Something other than email, though.
Yes.
Is that correct? So I guess the thing I'm a little curious about is it seems like, although the mother filed this motion to terminate the guard, it would seem to me that is almost like, a new proceeding that should have resulted in kind of more formal notice. Maybe not by the sheriff, but at least, a certified letter or something like that that would really kind of get the attention of the person.
That's a great question. There are some statutory requirements when you sort of reopen or refresh a case that there is a reservice. There was not that requirement for this case type. So that does happen in some family cases, but not for this one. We could make changes to our rules. It doesn't necessarily have to be a statutory change, but I think that's what you're thinking of, is that family cases that have been dormant for a long time, they often are reopened by a reservice.
Right.
That's required, and that was not a requirement for this case type.
Okay. All right.
Anyone else? Yes, Madam Vice Chair.
Okay. Could you help me understand why it would be police officers going to a house to take a child who obviously had not committed any act that was contrary to the law, rather than trained social workers? And I'm using that as a general term.
That I do not have information about, Representative. I apologize. I don't know why it would be a police officer being involved.
Thank you.
Representative Ball?
Thank you, Chairman Pearson. I guess I'm still old school, so, oh, sorry.
That's old school.
That's old school.
New school. Okay, got it.
So it seems sending a police, well, not to get the child, but the paperwork in servicing and all, why are we not using just certified mail to assure, and especially in a case that involves child custody is becoming in question? It just seems to me the easiest thing to do is require certified mail. You know where the address is, and if that certified mail comes back to you, that's a red flag that we better get there right away, because this person has a child, that they are responsible for, and they obviously may not be at that address anymore. So I'm just wondering, why did we stray away from old school and go to something where we still have people in our society that are not using email in the way that some other people are using it, that might be more professional people, but those of us in the older generation may not recognize that. Thanks.
That's a great question. One of the most consistent pieces of feedback we receive from the public is the desire to transition cases over to have more email use. And we do get complaints the other way. People really struggle to update the court when they change their mailing address. It's a very consistent issue that people just do not remember. You think of all the things you have to change when you change your address. You inevitably miss some. Every time I move, I miss some. People miss the court. So people miss very important filings by mail all the time. And so some folks have indicated to us that they use the same email their whole life. That would be easier for them. So we do get different feedback from different people.
Follow up?
Could we not use both systems? Continue with the certified mail, which is what, $5 or $7 or whatever it is, and still send a notice as well, just to make sure that we're covering both bases, especially since a child is involved in this.
I think it's a determination that there are statutory components, so certainly the legislature can adjust some of them, but for some regular notifications, you may not find that that's necessary. But because in the same way that there's reservice in certain family cases, this may be something where you determine that reservice is appropriate for certain kinds of motions in a guardianship case. And that could be statutory, it could be rules.
Yes, welcome.
Thank you for taking the question. Didn't you say, I think you said something that the court can check and see whether an email has been opened. So is that correct? And that's a procedure that you all could change within?
Without speaking on a particular case, I can say when I generally looked into this issue, I found that we did have the ability to see that when someone had not opened their email. I don't know if it's foolproof or maybe there's certain types of emails where it's easier than others, but we generally do. And so our thought of the easiest change to make was to mail if we had an unread email on an important issue.
Representative Macbeth, follow up?
So I've actually, would you believe, had a clerk's office call seeing that I had not opened something that had gone to my spam or that I had missed, and realizing that either I hadn't submitted a report or that it wasn't open and something was coming up. So, but again, that can't be something that we always require, but I think it probably is happening in some cases. And I mean, that's a really sorry case. I also will say that some attorneys, my mail goes to spam if I file in a court that I haven't filed in recently, like a superior court or something like that. So I think the spam idea, I mean, it is, if you all can check, if that is when people don't open their mail, it's probably not just the public. Although I know because it's happened. I mean, that's why, I'm familiar with it, so I know to check spam is what I'm trying to
That's
say.
good to know because we often don't hear. So I appreciate that feedback. That's good to know that that's a broader problem.
Representative Ball.
Thank you, Chairman Pearson. It's my understanding that email can also be sent with a receipt requested. So it could be as easy as just starting to send things out, receipt requested. That way you would have a paper trail. Thank you.
A question, since I am struggling to learn email and didn't know about this until just now. Is there a receipt sent when they open the email or when it lands in their inbox?
Chairman Pearson, I believe it's when they open it. It confirms that they have received it and they've opened it. Is that true?
This side of
Yes.
the room agrees.
Thank
with
you.
Yeah, that's good. Thank you. You gotta learn how to do that. Anyone else? Okay, good. Thank you. Who'd like to be on this subcommittee? Representative Gregg, I have asked that if we get a few people to work with her, this can be a subcommittee and she can chair it. Who else wants to work on this one? Representative Macbeth. Anyone else? Hmm? What?
I already signed up for a couple of committees, but I do think this is a very important committee. And if you need another person, I would be happy to help. But I do think that you are in good hands working within the departments.
No one is
But
accusing you
do-
of being greedy.
I know. Just to let you know, I do think this is extremely important.
Yeah, this email will go out to Representative Katab to see where she would like to slot in. And we'll give it the last few minutes. I know a couple people, thank you for coming. Got here late, but thank you for coming. Take a look at the handout sheet and see item number 1 to review. It's research title 4. We questioned, how does this have to do with family court? Subsection D, child support aspect of it is in the courts. So number 1 is something we could do. Item number 2 has to do with the ways to address perjury. We looked at some possibilities, but at least to come up with an explanations of why the court does what it does so people who are wondering would have an answer. I think everyone was here for 3. We said no to that. We were just here for 4. If there's anybody else who wishes to sign up for 1 and 2, Representative McMahon and Macbeth. Give you a few minutes to read it through and think it through. No, not a different one, perhaps an additional one. There are 3 committees and you can. Number 2, you're also on number 4 and that's okay? That would be possible too. Thank you. Greg, Ball, McMahon, and Lynn. Sounds like a law firm. You are right here. See? I'm on the ball. Anything else from Representative McMahon? You're on number 2. Do you wish to be on 1 and or 4 or neither? Neither. Okay, you're on number 2. That's good. Representative Long. So, running for Senate, I understand. Huh? You're running for Senate. It's in the paper, so it's got to be true. Okay, so you're going to be all full up, but you will, and
I am practicing saying no. It's hard work to say no.
I know.
And I have to practice.
I know.
I'm trying
When are
very
you going
hard.
to start doing that? Like next November, maybe?
I'm practicing now
Now.
saying no.
Okay.
After, I mean, who knows? I don't know if I'll have a primary. I might lose. Then I have a lot of time on my hands. But otherwise, I don't.
Okay. Then I think we're done. I will be in touch with Representative Katab. And if you could send those notes out, I'll talk to you about that. And
So comment, if I may.
what's that?
A comment?
What's that again? I'm sorry.
Comment? Can I make a
Yeah,
comment?
go ahead, Representative Long.
Yeah, just on item number 4.
Yeah.
If you could also look at, I've gotten calls from foster parents who've had a child taken where they didn't realize that child was going to be taken. So just on, look at the overall disposition of children that are moving from foster care, or like the case, the Guardian case also. Just any issues that we've heard on children being removed where the adults that were responsible weren't made aware of that.
Is that through the court, Pat, or
Uh,
through HHS?
I believe it in a couple cases that I heard, the foster parents, it's been through that HHS has gone over, not necessarily a police officer.
So although you are not going to be an actual member of the subcommittee, you are offering your services as the occasional consultant.
Oh, absolutely. I could build up that responsibility for item 4. Yeah.
Okay, so I will put this in lowercase letters.
Okay,
And that is the long and short of it.
very good.
You're welcome.
Oh, that was not. You could do better than
Oh, I
that,
have done
Mr.
better
Chairman.
than that. I know, but on the,
We need the long ball answer on this.
okay, thank you. It's a stretch. Anyone else from the committee? Okay, seeing none, I adjourn the work session on this, and we will get you the minutes from today at some point, and I will send out an email on the committees. When you go
Thank
to-
you as always, Mr. Chair.
You're welcome. When you send